Welcome to today's Explainer. Class, settle in, please. Right, let's dive straight into a landmark 1893 Court of Appeal decision that formed the absolute bedrock of contract law. Today we're examining Carlill v. Carbolic Smoke Ball Co, a case that fundamentally shaped the rules of offer, acceptance, and consideration. It is a brilliant example of how early commercial disputes actually forged the legal structures we still rely on today.
Now, before we look at the specific facts of the case, I want you to chew on this fundamental question. Is a promise made in an advertisement legally binding? I mean, can a seemingly absurd newspaper advertisement compel a company to actually hand over cash to you? Hold that thought in your mind, because the answer might surprise you, and it entirely depends on exactly how that promise is constructed.
Here is our roadmap for today's session. We'll start with the peculiar smoke ball promise itself, define the core legal issues, weigh the arguments before the court, examine the historic judgment, extract the core principles of contract law, and wrap up with your essential exam takeaway. Let's start with Section 1, the peculiar smoke ball promise. All right, pay close attention to the exact chronology of Mrs. Carlill's actions here. The Carbolic Smoke Ball Company manufactured this rather unusual product, boldly claiming it completely prevented the flu. They published an advertisement stating that anyone who used the smoke ball 3 times daily for 2 weeks and still contracted influenza would receive a £100 reward. Well, Mrs. Louisa Carlill saw this, bought the product, followed the instructions to the letter, and guess what? She still fell ill. When she asked for her £100, the company flatly refused.
Moving on to Section 2. Defining the legal issues.
When this bizarre dispute finally reached the Court of Appeal, the judges had to strip away the flu pandemic narrative and look at 5 very distinct legal questions. Was this advertisement a true, valid offer, or just a mere invitation to treat? Did she actually validly accept it? Was there sufficient consideration, meaning a real exchange of value? Did the company truly intend to create legal relations? And ultimately, putting all those pieces together, was a legally enforceable contract actually formed? This requires rigorous analysis, class.
Section 3. Arguments before the court. Let's step into the courtroom and look at the stark contrast in legal theory here. The company's defense? They tried to just brush the whole thing off as mere sales promotion, marketing puffery, really. They argued it was far too vague, totally lacked consideration, and hey, she never actually communicated her acceptance to them. But Mrs. Carlill? She anchored her claim directly on her physical fulfillment of their exact terms. A clear promise, conditions fulfilled, and she pointed to a very specific detail in their own ad to prove they absolutely meant business.
Which brings us to Section 4, the historic judgment.
Now, the court's attention, and indeed yours, absolutely must be drawn to this specific sum, £1,000. You see, in their advertisement, the company explicitly boasted that £1,000 had been deposited in a bank to demonstrate their sincerity and commitment to the promise, right? This wasn't just idle chatter, it was a verifiable financial action. And as the court brilliantly reasoned, and this is a fantastic piece of judicial logic, depositing real money in a bank elevated this from a vague sales pitch to a serious intention to create legal relations. Result? A resounding victory for Mrs. Carlill. A valid enforceable contract existed, and she was owed her money. Section 5. Core Principles of Contract Law.
Class, pens at the ready, because we're distilling the judgment into foundational rules now. First up, the general offer. This conclusively proves that yes, you can make a valid legal proposal to the entire world. The company argued you couldn't possibly contract with the general public, but the court clarified, and this is key, the offer is made to the whole world, sure, but the contract itself is formed only with that specific portion of the public who actually comes forward and performs the condition.
Next, we have the unilateral contract. This is a crucial concept where acceptance isn't communicated by words or a signature, but simply by the performance of an act itself. The company whined that Mrs. Carlill never called them to say she accepted. But the court held that in unilateral contracts, like reward notices, performance is the communication. You don't call the person who lost their dog to say you accept their offer to look for it. Simply finding and returning the dog is your acceptance.
Now, for those of you mapping this to the Indian Contract Act of 1872, look at how Mrs. Carlill's sequential actions perfectly illustrate Section 8, acceptance by performing conditions. She bought the smoke ball, used it exactly as instructed, and, well, got the flu. By performing these conditions, she accepted the proposal. And regarding consideration, the court found that her buying and using the product commercially benefited the company, so valid consideration was absolutely firmly in place. Finally, Section 6, the essential exam takeaway. If you only remember one thing from today, let it be this: ratio decidendi. This is your core takeaway. Performance itself constitutes acceptance in a unilateral contract without any prior communication, and an advertisement absolutely can be a binding offer if it demonstrates clear intent to be bound. The courts will enforce serious commercial promises, and they will not let a company hide behind the excuse of marketing puffery when they've explicitly backed up their words with actions, like depositing £1,000 in the bank.
All right, class dismissed. But I'm going to leave you with a final, provocative thought to ponder regarding the unilateral contracts you blindly enter into online every single day. How do you think these 19th century rules govern modern internet click-wrap agreements or digital reward programs? The technology has certainly evolved, but I assure you, the bedrock principles established by Mrs. Carlill and her peculiar smoke ball remain firmly in place today. Thanks for joining today's Explainer, and keep asking those hard legal questions.